this will be presented by Dusan POPOVIČ, who is working at the University of Belgrade, Faculty of Law. And the title of the presentation is Defamatory Online Comments and Critical Analysis of the European Court of Human Rights and the Court of Justice of the EU. Professor, the floor is yours.
Thank you very much. Dear colleagues, ladies and gentlemen, first allow me to thank the Ferenc Madl Institute of Comparative Law for initiating and organizing this project. I'm delighted to be able to cooperate with my colleagues from Central and Eastern Europe, and I fully agree with what was said at the very beginning in the opening remarks by Professor Szilágyi, that normally we cooperate with between Western and Eastern Europe, but rarely among Eastern and Central Europe. So I'm truly hoping that this circle, this Central European Professors Network, will continue its research activities. Also, I would like to thank Professor Vielec, who is the head of our research group and who could not, unfortunately, be here today with us. As you see on the slide, this part of my research was related to defamatory online comments. This is part of the research which is not published in this book, but will be published in another publication within this project. So, when I was thinking about how to start, I actually realized that most of you do not remember the moment when the internet started to be omnipresent. Well, most of you on this side of the table, but we sitting on this side of the table, we remember very well the end of 1990s when this has become really fully present in our lives. So at that moment, internet and this online communication was seen as a value in itself, as a kind of a freedom, which was not abused at first, but in time there was a lot of anonymous internet communication, which started to be abused, especially in this sense, in the sense of defamatory comments, and this developed quite a lot when this phase of Internet 2.0 began, where every news had began to be commented on by the users, and particularly in this period of social networks. And there is, of course, supranational and national case law which deals with defamatory comments online, and these cases are decided slightly differently depending on whether the comments are moderated and unmoderated. Whether this moderation takes place ex ante, so somebody is checking the comments before they appear, before they become accessible to the users, other users, or it is exercised ex post. But before we analyze certain of these decisions by the European Court of Human Rights and the Court of Justice of the European Union, I would just like to draw your attention to the fact that normally we try to compare ourselves to the US legal system, because US law is considered to be the cradle of the freedom of expression in the legal sense of the term. However, this comparison is basically not possible, because we don't have the European counterparts of some legal instruments which exist in the United States, and this legal framework in Europe, particularly in the European Union, it's quite complex and consists of not only the European Convention on Human Rights, but also for EU member states of the EU Charter of Fundamental Rights, and of course a number of national constitutions and case law of supranational and national courts. But clearly the most important piece of legislation and legal source is the European Court of Human Rights and its Article 10, which proclaims the freedom of expression, which includes the freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. But there could be some restrictions on freedom of expression, and it is up to courts to decide whether these restrictions are justified in a particular case. Since there are some time restrictions, I would not spend more time on the analysis of the legal framework, but would like to comment on certain cases. First, the case law, the Court of Justice of the European Union, and the most notable case in this area, I would say, the Eva Glavišnik-Pišek case. I hope I pronounced it well. Basically, the case law of the Court of Justice of the European Union revolves around the interpretation usually of the EU Directive on Electronic Commerce, and this is a directive which was already mentioned and analyzed by Professor Kolte in the previous section. The problem with this directive is that it was adopted in 2000, so 21 years ago, and it is no longer up to date, and it does not reflect the technological developments which we are facing, especially in the last, let's say, five years. And this directive sets the rules which are related to the dissemination of online content, the notice and takedown procedure, the prohibition of general monitoring duty. However, it does not prohibit the specific monitoring duty, which can be imposed by public authority. And this Eva Glavišnik-Pišek case is related to an Austrian politician who suffered from a certain defamatory comments, and basically what the court had to decide in this case is whether it can be requested from a social network to take down not only the identical but also similar comments content-wise, and also what would be the territorial scope of this taking down order. So the Court of Justice of the European Union concluded that the removal or disabling of access has to be undertaken in the observance of the principle of freedom of expression, and that a service provider that hosts third-party content may avail of this exemption on condition that it does not have actual knowledge of the illegal activity or information, and as regards claims for damages, that it is not aware of the facts or circumstances from which the illegal activity of information is apparent. Regarding the issue of similar content, the Court of Justice of the European Union did allow that the order concern similar content as well, and with respect to the territorial scope, the court concluded that Article 18 of the Directive on Electronic Commerce does not make provision for any territorial limitation for the effects of these injunctions. So this is quite important, given that as you know, internet has global consequences, and once you publish certain information, it has global impact. And the European Court of Human Rights has a much richer, wider case law track on the issue of freedom of expression and defamatory comments, of course. And two most notable cases were cases Delphi versus Estonia, MT versus Hungary. both of these cases related to comments which were published below certain articles and which were found to be defamatory. And although the circumstances were quite similar, I would say, the court reached somewhat different conclusions, which has been criticized in legal theory as a certain inconsistency in the case law of the European Court of Human Rights. So due to some time constraints, I would not enter into the details of the facts of these cases. You can read all that in my paper, in many other which discussed these two cases. But I would like just to try to summarize where the case law stands. So in Delphi versus Estonia, the European Court of Human Rights listed 4 specific factors which should guide us when judging whether this balancing of different interests is properly conducted or not. The first one would be the context of the comments. The second one would be the measures which are applied by the platform in order to prevent or remove the comments. Basically what I said in the introduction, whether the comments were moderated or not, whether the moderation took place ex ante or ex post. The liability of the actual authors of the comments as an alternative to the platform liability. So basically, you would need to check whether within the national legal framework it was possible to sue the actual authors of the comments instead of initiating proceedings against the platform operator. And the fourth one, the consequences of the domestic proceedings for the platform itself. And in the second case, MT versus Hungary, the court added the 5th factor, which would be to explore what are the consequences of these comments for the victim of the comments. I ran a little bit through these cases because they're not so recent, but I would like to spare some more time in the concluding remarks on something which is quite recent, and this is the proposal of the Digital Services Act. But before that, just a few remarks once again on the EU Directive on Electronic Commerce, which is still in force and somewhat outdated, I would say. This directive envisaged 3 categories of intermediaries: mere conduits, caching, and host content. And with respect to host content, there are certain differences compared to, I mean differences in technical sense compared to what host content providers were in 2000 and what they are in 2001. And what we can learn from the case law in the last 20 years regarding the interpretation of this directive is that clearly the Court of Justice of the European Union allows for specific monitoring obligations to be imposed under certain conditions. I would say that one of the most spread misconceptions is that this directive on electronic commerce harmonizes the conditions for holding intermediaries liable, and actually this is not true. It harmonizes the conditions for the exemption of the intermediaries from liability, and this is one gap that really needs to be fill in at some point. And with respect to the proposal of the Digital Services Act, that is also something which was tackled by Professor Colte. There are some provisions in this proposal which are related to the comments. So the DSA proposal introduces the obligation for service providers to act when they receive order in relation to specific item of illegal content. And when you check the proposal, to look for a definition of an illegal content. The illegal content is defined as any information which in itself or by its reference to an activity, including the sale of products or provision of services, is not compliable to European Union law or the law of a member state. However, there are some more details in the recitals. So the recitals refer specifically to hate speech or terrorist content and unlawful discriminatory content, or the content which relates to activities that are illegal, such as the sharing of images depicting child sexual abuse, unlawful non-consensual sharing of private images, online stalking, the sale of non-compliant or counterfeit products, the non-authorized use of copyrighted protected material, or the activities involving infringements of consumer protection law. And there are some additional rules which, if this is adopted in the form in which it is presently, additional rules which relate to online platforms, such as reporting mechanisms for illegal content. So, given the fact that this proposal of Digital Services Act referred to illegal content which may be disabled or removed under certain conditions, it seems that not all type of online comments will be caught under this new proposed mechanism. So I fear that we will go back to this difficult distinction that and mechanism which is set by the European Court of Human Rights to make a distinction between what is a manifestly illegal comment on the one hand and a merely offensive comment on the other hand. So I'm afraid that if the text of this proposal remains the same, we will not get a clear answer to that question. What is manifestly illegal and what is merely offensive, and the consequences are dramatically different. Thank you.